Well, good afternoon, everybody. Happy Thursday to you. The Thursday before Thanksgiving. So, Bill O'Leary here, Legacy Planning Law Group. Um, uh, just one moment. Let me clear this out. So, Bill O'Leary. So, coming to you live, and as part of our Thirsty Thursday series, as we refer to it. So, again, I'm a lawyer, and what I do is estate planning, wills and trusts and estates and this sort of thing, and elder law. So what I do is every week at about this time on Thursday, come to you live talking about a different topic. Maybe some issues that we've seen, issues that you might be aware of. So if you're thirsty for knowledge, you come to the right place. Today's topic, kind of a fun one with Halloween just 3 days away. The topic is there's nothing spookier than dying intestate. Okay, dying intestate. Boy, is that spooky. So, look, if you've heard me speak in the past, maybe at a seminar or even on social media or whatnot, you know how passionate I am about estate planning. In fact, the critical importance of estate planning, and at a bare minimum, creating a will, and in many situations, creating a trust is a better solution than a will. But I'm very passionate about that. But unfortunately, it's quite common for people to pass away without ever, having taken any steps to legally define their wishes for how their estates should be handled after they die and who's going to inherit what. Okay? So they've got nothing. Maybe the back of a napkin is the best that they have, or maybe a handshake at the dinner table. So when a person dies without leaving a will, their estate, it's described as being intestate, and it's kind of legal jargon. Intestate law or intestacy law refers to the process of determining who's going to inherit what of the deceased person who leaves, more assets than they do have debts. But they die and they fail to have a will, or maybe that there is a will but it's inadequate. It doesn't address some key points. In which case, is going to be what's called a partial intestacy will apply. Now, keep in mind, many estates without a will are required to pass through probate in Florida. Again, unless the estate is sort of insolvent, underwater, more bills are owed than there are assets in the estate, in which case then it's kind of a moot point. But assuming that there are more monies, assets, property in the estate than there are bills to pay, we have to turn to the intestacy laws, and they help determine who has a right to inherit assets. Now, this can be an incredibly complex process, and a lot of times it ends up raising difficult questions. If you die with both a spouse that's living and children who are living, well, who should inherit your assets? Let's say you have no children or no descendants, okay? And your spouse passes away before you do, but let's say your spouse was married previously to being married to you. Who has a claim to your estate? So in Florida, intestate succession will depend on the circumstances of the deceased person's living relatives. You've got to evaluate and look at them, as well as those of any spouse that may be living. Okay. So, for example, here's a sort of an example, case in point. If the deceased person leaves behind both a living spouse and living descendants, and descendants can be children or maybe children of children, think grandchildren, where the child has predeceased but they leave children. So again, if the deceased person died leaving a spouse as well as descendants, and if all of those descendants of the deceased person are also descendants of the living spouse, and if the spouse has no other living descendants, well, under the intestacy laws, the spouse is entitled to the entire probate estate. Well, here's a different situation. What if the deceased person leaves behind descendants but doesn't have a spouse? Well, in that case, the descendants are entitled to the entire estate. What if the deceased person leaves behind descendants and a living spouse, but what if those descendants are not related to the living spouse? okay? Maybe they came from a previous spouse. Then what happens? Well, in that case, under the intestacy laws in Florida, the estate is split 50-50 between the spouse, and the other 50% will be split among the descendants. What about this situation? A deceased person leaves behind descendants, okay, who are also descendants of the surviving spouse, but the surviving spouse also has descendants of his or her own who are not descendants of the deceased person. You follow? What's the outcome there? Well, the surviving spouse only inherits 50%. And what if the deceased person had no spouse and no descendants? Where does the estate go? The Florida intestacy laws sort of has a hierarchy of heirs, starting with parents. And if there are no parents, then you look at siblings and you move further out from there in the family tree. And speaking of siblings, half siblings, okay, half sister, half brother, only get a half share as compared to a full share that full siblings will get. And oh, by the way, if the deceased person, let's say, wanted to give money to a charity, well, guess what? Under the intestacy laws, the charity is cut out altogether because the intestacy laws don't provide anything for the charity. So as you can see, the scenarios can become fairly complex without doing proper planning. So now keep in mind, not all property will be included in the intestate estate. Only property that's part of the probate estate is included as part of this intestacy analysis. So that usually means property that was in the sole name of the deceased person. Assets that are not part of the probate estate may include assets that may be in a living trust, maybe some retirement funds, life insurance, annuities, and maybe certain financial accounts that are called pay on death accounts or transfer on death accounts. Typically, those are not part of the probate estate. So even with clear statutes regarding succession in Florida, look, having a relative die without leaving a will can lead to a lot of sort of difficulty, a lot of angst, sort of strife among family members. So it's always in your best interest to at least create a will before you die to avoid conflict and other major issues. And oh, by the way, in many situations, there's a even better solution than a will, and that's with a trust. So look, if you'd like to know more about sort of the intestate laws and the importance of having a will, then we'd love to talk to you. We'd love to help you out. So as I do every Thursday during these talks, go ahead, reach out to us. Book a free 15-minute phone call that we call our discovery phone call. Just hit the book now button on the Facebook page or Google us LegacyPlanningLawGroup.com. This 15-minute phone call is complimentary. If you've enjoyed this video, I'd ask that you like it, better yet, share it with your friends, okay? Share it with your friends. So I hope you've enjoyed this talk that's named There's Nothing Spookier Than Dying Intestate. As I said, I plan on giving another talk next Thursday. I'll go live on Facebook then at the same time as part of our Thursday series. Same time, same day, just a different topic. So, Bill O'Leary signing off for now. And really on behalf of everybody here at my firm, Team Legacy, hope you have a wonderful, safe Halloween weekend. Those going to the Florida-Georgia game, or for those Georgia Bulldog fans, known as the Georgia-Florida game, have a good time. Be safe and responsible, and go make it a great day and make it a better world.